In this third part of the legal context lecture, we're going to look at how the EEO laws are applied or administered. Number one, we can see how it's applied through interview questions, right, and what is appropriate or inappropriate in terms of interview questions. And then we'll look at the role of the EEOC and the role of the OFCCP in helping organizations follow EEO laws and executive orders. So, starting with the improper interview questions, they're called improper interview questions versus illegal questions. And I know that we use the term interchangeably. That's an illegal question. Technically, it's not an illegal question. It's really an improper question. Because any question is fair game. No one has written laws that says you're not allowed to ask that question. You can ask it. You're just not allowed to use the information. And once you ask the question, how do you not know and not use that information? So you can ask the question all day long, but then you have to be able to show, which you're not going to be able to show, that you didn't use that information when making your hiring decision. So it's better not to ask the question at all. It just doesn't leave you open for any legal ambiguity in that context. So all of these, what are they getting at? Well, number one, how many children do you have? That is a form of sex discrimination because typically people assume for men having children means they're stable and it's a good thing. But for women, it's considered a bad thing. So if women have children, then they are not going to be as dedicated to their job, or they're not going to be able to give the hours of the travel that the job needs. And that's not a decision for the organization to make. They can set the expectations. These are what we expect of you. We expect you to travel. We expect these number of hours from you. And from there, then the person can say, I can or can't work that. And if they can't work that after it was established during the job and after it was made clear to them, one would expect probably in writing, if they can't do that, then that's a different situation than someone who is not even given a chance to do the job and making an assumption that, because they have children, they'll never be able to do those sorts of things. So you have to recognize what it signals to people. Your native language gets at issues of ethnicity, right? And so that we don't want to be discriminating based on someone's ethnic origin. And so if we're asking people what their native language is, we assume that they don't have an ethnic origin here from the United States, and thus, we could be accused of discriminating based on ethnic origin. Clubs and social organizations, these could either have a positive or negative impact, but generally speaking, some clubs and social organizations can indicate that you might be engaging in activities that the organization doesn't like. For example, if you are you're a teacher in your church's summer vacation Bible school, or you're a religious education instructor at your church on Sundays. What if the organization wants to discriminate against you because they don't believe your religious practices? They don't like your religious practices, and so they've left themselves open to discriminate, to be interpreted as possible discrimination against you because of religion. Also, if you're engaged in volunteer activities with causes that the organization may not like, for example, volunteering for the Human Rights Campaign, which does advocacy for LGBT people. And so if that person says, oh, I volunteer for the Human Rights Campaign, you might make assumptions that they're gay or lesbian or bi or transgender, or that they support those rights, and therefore you could say, well, I don't want to hire you because you believe in gay rights and I don't, that kind of thing. The last item, are you planning any medical procedures? That's really not anybody's business. If you say, yeah, I'm planning a knee replacement in about a year or two, the organization, then might be inclined to say, well, I'm not going to hire you because, you're going to cost me more money because the insurance will go up. So, or, if you're having a problem with your knee, then I don't want to hire you because, you're going to have a disability. The Americans with Disabilities Act does not allow us to ask those questions, nor does it even allow us to ask for people to concede to a medical exam before a job offer is made. The job offer has to be made, and then they have to pass the medical exam as long as they can do the the functions of the job, the required functions of the job, then they would get the job. But if you're asking someone that this job 100% of the time requires you to lift things, and then you don't pass the medical exam because you can't lift things, then of course you wouldn't get the job. But if 1% of your job is lifting a box on occasion, and the organization says to you, you're not going to get this job because every once in a while you're going to have to lift a box, and you can't lift a box, so therefore you're not going to do the job. That's a totally different animal. And if you think that's an unusual or unrealistic scenario, that actually is a truthful scenario that happened in a particular legal case where a gentleman once a month had to lift a box and put it on a shelf, and he wasn't allowed to lift the box. The company fired him because they said, once a month you've got to be able to do this job, and if you can't do it, then we can't accommodate you. In the end, they were ordered to accommodate the guy because all they needed to do was bring somebody in who could lift up the box and put it on a shelf for him once a month. So, companies will go to any length to draw a line in the sand about whether or not they want to, go out of their way to help somebody. So it is not unusual to hear those kinds of reasons, that people don't want to, make an accommodation, whatever it is. So just remember, questions aren't illegal, they're improper, because if it comes back that that question was asked, it's going to be really difficult to deny that you didn't use that information when you were making the hiring decision. So better not to even go there or even talk about it, or even entertain the issues. Protects you, protects the company. So now getting into some of the differences in terminology. What do we mean by EEO or equal employment opportunity? What do we mean by affirmative action? What do we mean by staffing quotas? EEO, or equal employment opportunity, means that employment practices are designed to be used in what we call a neutral manner, facially neutral manner. So it means that we apply the same standard to everybody, regardless of race, sex, religion, you name it. So the expectation is that if I hold you to one standard, I also have to hold the other person to the same standard. When this gets violated, for example, when we decide that when we're engaging in disparate treatment, typically we treat someone differently because of their race, because of their sex, because of their ethnicity, because of their religion. And for example, if someone, a male applies for a job and he only needs 2 years experience to be able to do it, but a woman needs to demonstrate more years of experience in order to be minimally qualified for the job, that's not applying the standards in a facially neutral way. So under disparate treatment, we're violating the issue of facially neutral, meaning treating everybody the same. There are times, though, that even when we treat people the same, we have an adverse impact. And again, remember, that's the second type of EEO discrimination under Title VII. So we can treat people the same, but the standard may be set in such a way that it has an unexpected or unintended impact against a group. So even though it seems to be neutral, and in fact it has a negative impact against one group over another. So again, we have to recognize that the goal is to be facially neutral, to treat everybody the same, and expect it to have the same impact down the line. And that's our goal in EEO law. Now, with affirmative action is about the proactive approach that we take to attract qualified women and minorities to our organization. And we make sure that we're doing it in a non-discriminatory way. So that means we can proactively, affirmatively attract more people to our company. It doesn't mean that we hire someone simply because they're a woman or a minority. But the assumption is if we have 2 equal candidates and we are underutilized in terms of the number of women or minorities in our company, if they're basically neutral or the same candidates, we can say, because they're the same candidates, I'm going to hire the woman over the man, or I'm going to hire the minority person over the majority person, because we're underutilized, with employees in that particular area. That you can do, but you can't say, well, I'm going to hire this unqualified person for the job simply because I need to have another woman in the company, and this person's not qualified, but I'm going to hire them anyway. No one ever states that affirmative action requires us to hire somebody who is unqualified for a job, no matter what anybody says. And affirmative action just isn't about attracting and recruiting people. It's also about the training programs that I might have in my company, or it might be about the corporate social responsibility programs I have in my local community, what I can do to make my community more readily available to be hired in those situations. And so that's our goal, is to try to find ways to improve the pool of applicants that we get, actively and proactively, and reactively getting more people involved in applying. Staffing quotas is where we establish specific requirements that require certain percentages of disadvantaged groups to be hired to equalize the proportional representation in the company's workforce. Again, when we think about staffing stock statistics, where we need to make sure that our company's mix represents the mix in the local labor market, we need to be incredibly careful that we are proactively recruiting diverse candidates the best way that we can. And so with staffing quotas, it's really important that we make sure that we're not doing quotas which are illegal, and we're simply saying, we are doing the best we can to recruit more people from these underrepresented groups so we can increase the likelihood that we're going to hire them. But we can't simply hire an unqualified person just to have a quota of a certain group in our company. That's against the law. Now, going into a little bit more detail on affirmative action, as I said, if we have equal candidates, we can give preferential treatment to one group over the other. And affirmative action plans have very clear rules about when you can violate sort of this non-preferential treatment activity. So affirmative action plans can give preferential treatment when it is remedial in nature. So when we are really grossly underrepresented with certain groups, we can proactively go out and only hire those groups in order to help remedy the situation and make our company more diverse. It should not exclude all non-minorities. It doesn't mean that we don't hire non-minorities or majority group individuals. It means that, when we have equal candidates, we can give preference to the non-minority, but that doesn't mean we stop recruiting non-minorities or we don't interview and bring them into the recruiting process or the selection process. We have to absolutely do that, because then we're violating EEO law. So affirmative action asks us to actively recruit all groups equally, but sometimes we have to make an extra preference, an extra effort to recruit women and minorities to the company. And we cannot say, well, even though this person was heads above the best candidate, we're not going to hire them. We can't really do that either. So really, when we're talking about the preferential treatment, it's really when they are, for all intents and purposes, relatively equal candidates. Then we can make some of those preferential choices for the minority groups over the majority groups to remedy really bad problems with lack of representation. Again, with this preferential treatment, this is not a permanent situation. This is not something we would permanently do. It's something that we would do in a temporary basis in order to help remedy when we don't have a representative workforce. And so it needs to be very temporary. We can say for 6 months or a year, whatever it might be, but it has to be a temporary situation. And it should be a formalized plan. It should be written in your affirmative action plan that says, this is what we're going to do, this is why we're going to do it, this is the time frame within which we're doing it, we will stop doing it either at this date or if we have better representation one way or the other. And our goal is, if we have equal candidates, we will give preference to the minority group that's underrepresented. If there are candidates that really stand out as better and they're not in those protected groups, we will absolutely commit to hiring the best person for the job. But again, you have to be really careful in the language that you use, and it's always good to work with an attorney, an EEO law attorney, to make sure that you're managing that well. So what is the EEOC and what is their role in the whole process of equal employment law? The EEOC, the Equal Employment Opportunity Commission, is a commission of representatives who enforce federal statutes. Title VII, age discrimination, pregnancy discrimination, ADA, Rehab Act, Civil Rights Act of 91, Equal Pay Act of 63, and the Genetic Information Non-Discrimination Act, the GINA Act from 2008. They are responsible for reviewing cases as they come to them. They typically get over 90,000 charges each year, people complaining that there is a problem in their company with discrimination, and they look to the EEOC to acknowledge that, in fact, discrimination, it looks like discrimination occurred, that someone has made their prima facie case for discrimination. And from there, either the EEOC will be actively engaged in the case, where they will take on the case and represent you in the courts. And that's usually for very unusual cases or things that they think are going to have a big impact or may set good precedent. Or the EEOC will give you an acknowledgement that you would then bring back to your employer. It says, I went to the EEOC. The EEOC acknowledges that I have a case, so I'm bringing this to you to fix this. Otherwise, I'm going to find an attorney and go to court. So the EEOC doesn't always take every case to court. It sometimes just gives the rubber stamp that says, you are correct, this is a form of discrimination, and you can take this to an attorney and to your organization, and hopefully they'll be able to fix the problem. And so sometimes that works, sometimes it doesn't. Every organization has to figure out how they want to best handle that. The EEOC is not, does not have the force of law behind them themselves. Like, for example, they can't come in and say, oh, I see discrimination and therefore I'm going to fine you. They can't do that. They can bring court cases to court, but they cannot in and of itself make a ruling or that is enforceable by law. So they would then have to bring it to a court and have to convince a court that there was issues and concerns there. What the EEOC does do is it educates people and encourages them to facilitate voluntary compliance with the laws. It educates people on the EEO laws and how they should be managed. So they provide information and they can provide rulings. And then from there, if they find that there is a case and that the organization is willing and able to listen, hopefully then we can avoid lawsuits in that situation. The Office of Federal Contract Compliance Programs, or OFCCP, is a little bit different than the EEOC. The EEOC does not have the force of law, and it's responsible for administrating all the EEO laws. The OFCCP is responsible for administering any executive orders or rules around federal contractors and subcontractors. So, for example, 11246 and 11375 executive orders, which are affirmative action, OFCCP is responsible for administering those. It's also responsible for administering the Rehab Act and the Vietnam-era's Vets Readjustment Act. So all of those have to do with contracts with federal employers, federal contractors rather, sorry. So if you have a contract with at least 50 employees and receive $50,000 or more in grants, goods, and services, you have to do affirmative action and have affirmative action plans around all those particular areas, whether it's males and females, whether it's the Rehab Act for those with disabilities or the Vietnam-era Vets Act for the vets. But the OFCCP has enforcement behind them, so they can go in and fine a company, whereas the EEOC cannot. So if you are not in compliance on your contract, the OFCCP can cancel your contract, or it can fine you to make sure that you are in alignment with the contract. So as it says here, the OFCCP's mission is to ensure non-discrimination, particularly with respect to being in compliance for federal contracts. So it wants to make sure that all employment decisions are inclusive, are supportive of diversity. So they will conduct compliance reviews and complaint investigations. They can actively fine a company or charge them if they are not in compliance. It does enforce affirmative action, but most of its activities, as it says here, is focusing on class action discrimination, which is sort of widespread discrimination across a whole bunch of different situations. And so it might look at an industry, it might look at a particular bunch of companies that have contracts, but generally speaking, they will seek out and investigate cases and really do a systematic review of every company's affirmative action plan to make sure they are in compliance. So, I mean, the government is not something to mess with. If you're not in compliance for your federal contract, you certainly could lose your contract. So you always want to make sure you're monitoring that and are completely compliant. One of the concerns in all of the EEO work that we're doing, all the legal issues, is who or what constitutes an applicant. There's very clear rules on whether or not someone actively is an applicant or whether it's somebody who is more of a casual job seeker. So there are two legal definitions of an applicant regarding our EEO law. Number one, only applicants may establish a prima facie case of unlawful discrimination regarding hiring decisions under state and federal discrimination laws. And so you have to actively be applying for a job, filling out an application saying, I'm interested in a job with this company. Number two, employers must determine who qualifies as an applicant in order to identify the gender and race of all applicants to evaluate whether its hiring practices have an adverse impact on men, women, or minorities. So an applicant is somebody who submits an application, who makes an inquiry online. You have to have a determination of this person is considered an applicant, this person is not considered an applicant. So each employer can do that, but then it has to be consistently applied. Because then once you keep track of all of your applicants, you are responsible for keeping track of gender and race of all those applicants so that you can do adverse impact calculations. So you can look at the flow statistics and apply the 4/5 rule to your flow statistics. You can do your stock statistics and again apply your 4/5 rule to your stock statistics to make sure that your applicants are representative of the available qualified groups in your local labor market. The question of whether or not somebody is an applicant is critical to establishing the proportions of the applicant pool for those legally protected groups. So once you understand who qualifies as an applicant, you've got a clear definition of who is an applicant and who is not, but then that's when the application of the rules and things like that have to apply. So be clear, again, on making sure that you have a clear definition of when somebody is considered an applicant, that fully puts them in the pool to be considered for employment. And then once those people hit that threshold, then you can consider them applicants, and you can apply your 4/5 rule applications for adverse impact and things like that. The OFCCP has a very clear definition of who is considered an applicant, and it's really important that you follow these guidelines if you have federal contracts. And even if you're applying via the internet, there's still a presumption that that person is considered an applicant. So, number one, the individual submits an expression of interest in employment through the internet or related electronic data technologies, which means if they send you an email with their resume, or if they apply in an online portal, those are considered an expression of interest in employment, and that's considered an applicant. The contractor considers the individual for employment in a particular position. So again, assuming that I have a position available, I would consider them an applicant in that context. The individual's expression of interest indicates the individual possesses the basic qualifications for the position. So if they expressing an interest, and if you have done a good job of communicating what the minimum expectations are, and that's legally sound in terms of job relatedness, then that person, if they meet those criteria, they are considered an applicant. The individual at no point in the contractor's selection process prior to receiving an offer of employment removes himself or herself from further consideration, or otherwise indicates he or she is no longer interested in that position. What that means is the person applies, and you are in the middle of the recruiting process, and the person doesn't remove their resume from the pool. They don't say, I got another job, please don't consider me anymore. They keep themselves in the pool. So that the person has to proactively remove themselves from the pool. Otherwise, the assumption is that they are considered an applicant, no matter what. So again, assuming that those four criteria hold, that person is considered an applicant under the OFCCP. So that's really clear for federal contract compliance what that is. And again, if you have federal contracts, or you think you might be interested in federal contracts, having a uniform policy on what is considered to be an applicant would be the most appropriate. So if you even remotely think you want to have contracts, you might as well set the standard right up front with those criteria. So if you follow these criteria, that's a good rule of thumb whether or not you have a federal contract.